Thank you very much, Mr. Chairman. Mr. Chairman, it's great to have this hearing. Thanks for calling it. Thanks to all of our witnesses for being here. Professor Shaw, nice to see you again. Let me just start with you, if I could, Professor Shaw. You talked about the fact that there have been lots of rulings against the Trump administration. That's absolutely statistically true. I disagree with almost all of them. In fact, I think all of them. But the issue of this hearing really isn't the rulings, is it? It's the remedies. Would you agree? And those are distinct things. You may think that the ruling is quite correct, but that's actually not what we're talking about here today. We could have a hearing on that. Maybe we should. But we're talking today about the remedy. And the question is a remedy that binds parties who are not before the court, is that an appropriate thing? I mean, aren't you concerned about judges binding non-parties in their remedies? You may love the ruling, but even if you do, don't you think it's a little bit anomalous for courts to be going out there and binding parties who are not before them? I mean, is that something we want to encourage?
Fellow patriots, welcome back to the channel. If you're sick and tired of double standards in Washington, if you're fed up with activist judges legislating from the bench, and if you still believe in the Constitution of the United States, we've got a video today that'll light a fire in your soul. Today, we're reacting to a recent Senate hearing where a so-called legal expert, Professor Shaw, gets absolutely grilled on one of the most dangerous tools activist courts have been using, the nationwide injunction. And let me tell you, this thing is being abused like you wouldn't believe.
Senator, I think that judges have been issuing rulings that impact non-parties since Marbury versus Madison, right?
So you're not concerned about it?
I'm not. I absolutely think that they can be abused, and
wait a minute. You were very concerned about it just a couple of years ago. Yeah. You said in response to a nationwide injunction on the Biden FDA's mifepristone rules, and I quote, "This injunction's a travesty for principles of democracy, notions of judicial impartiality, and the rule of law."
I think I've been consistent today. That was issued by Judge Kaczmarek in a single judge division. They're a problem. Those are a problem.
With him personally? Wait,
no.
Your testimony is if it's issued by Judge Kaczmarek, it's bad?
No, sir.
It's personal?
That is not my testimony.
Is the problem with the injunction? You were criticizing the universal injunction
issued by a judge in a single judge division. I've been very clear today that those are a problem.
By a Republican judge in a Republican division, then it's bad.
No, Senator.
Otherwise, it's fine.
No, Senator. I think that single judge divisions are a problem.
What is the principal difference? I'm looking for a principle. I understand you hate the president. I understand you love all of these rulings against him. You and I both know that's not a principle. You're a lawyer. What's the principle that divides when issuing a nationwide injunction is okay when it's not? When the Biden administration was subject to nationwide injunctions, you said that they were travesties for the principle of democracy. You didn't say the referral to Judge Kaczmarek was a travesty. You said his injunction was a travesty for principles of democracy. Yeah. So, in other words, the translation is just you didn't like the outcome. Is that right?
No, Senator. Look, we're talking about, I don't think Article 3 precludes this form of relief. So we are talking about prudential considerations.
Prudential meaning political?
No.
Then give me, so far I have yet to hear it. You've been questioned by multiple senators. I have yet to hear a principle other than the fact when you like the ruling, you think it's great to apply it nationally, including non-parties. When you don't like the ruling, it is a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law.
Look, Senator, I'll say I think I am self-aware enough to know that my view of the underlying legal question, I am sure colors my perception of the remedy. I think that we should all acknowledge that. And yet I do think that
why shouldn't we stop nationwide injunctions for everybody?
I think that's
what we're talking about today.
Because I'm not willing to leave without relief non-parties who are
injured. No, you're not willing to leave without the ability to bind President Trump.
No, I think that...
I mean, when it's Biden, it's okay. No. When it's Biden, it's a travesty. When it's Trump in office, it's no holds barred, whatever it takes, right?
I believe in a powerful...
What was it that President Biden's staff said? We've got to do undemocratic, unconstitutional things to save democracy. Why is this the same
I believe in a powerful president. I do believe in presidential power, but power and constraint are not at fundamental odds.
What is the principle? What is the principle? The legal principle. You've referenced prudence. You've referenced the judges you don't like. What's the principle of when an injunction binding non-parties, which was never done in this country before the 1960s? And let's see the chart, the Trump chart, which was done really only once Trump came into office for the first time. You don't think this is a little bit anomalous? You don't think that's a little bit strange?
A very plausible explanation, Senator, you have to consider is that he is engaged in much more lawless activity than other presidents, right?
You don't think this was never used before the 1960s, and suddenly Democrat judges decide we love the nationwide injunction. And then when Biden comes to office, actually.
It's Republican appointees as well, Senator.
No,
and the 1960s is where some scholars locate the beginning
Can you
of this.
identify
But
one
others,
before then?
Mila Sahoni, who's another scholar of universal injunction, suggests 1913 is actually the first, and others in the 20s.
The Republic endured for 150 years before there was a nationwide injunction.
Well, the federal government was doing a lot less until 100 years ago. So there's many things that have changed in the last 100 or the last 50 years.
So long as it is a Democrat president in office, then we should have no nationwide injunctions. If it's a Republican president, then this is absolutely fine, warranted, and called for. How can our system of law survive on those principles, Professor?
I think a system in which there are no meaningful constraints on the president is a very dangerous system of law.
That's not what you thought when Joe Biden. That is not what you thought when Joe Biden was
every president
You
is
said that is
constrained
not what
and
you
must
said.
be.
You said it was
Absolutely.
a travesty for the principles of democracy, notions of judicial impartiality, and the rule of law. You also said
Supreme
when
Court
Joe
Senator
Biden
agreed-
was president. Wait a minute.
agreed 9-0 with me on
you
that
also
case,
said
to
when
be
Joe
clear.
Biden was president, you said the idea that anyone would foreign shop to get a judge who would issue a nationwide injunction was just politicians, just judges looking like politicians in robes. Again, it threatened the underlying legal system. People just trying to get the result they wanted. It was a travesty for the rule of law. But you're fine with all of that if it's getting the result that you want.
Sir, the Supreme Court agreed unanimously with me in that case, right? There was no standing. The case should never have been allowed to proceed.
Wait,
the combination of parties without standing and the single-judge division.
No. We're talking. No, they did not. They did not issue a ruling on the nationwide injunction. You criticized the injunction nationwide. Listen,
issued in a case
we
where
can go
no
round
one
and
had
round on this.
standing.
Here's the thing. We've now gone 6 minutes, and Senator Kennedy had you for 6 or 7. You couldn't identify a single principled basis. We all know the truth here, which is it's not just you. It's most of my colleagues over here on this side of the aisle, who I respect a great deal, and they were raising very principled objections to the nationwide injunction just 6 months ago, maybe 9 now. And you're probably right. My point is that all that's changed in 9 months is the occupant of 1600 Pennsylvania Avenue. And I realize that my colleagues on this side of the aisle very much dislike that individual, and I realize that you think that the rulings that he has lost are fundamentally sound. We might grant all of that. I disagree with all of that, but we can put that to one side. The question we're talking about here is, should judges, single judges, district court judges, be able to bind non-parties who are not in front of them? And you used to say no, now you say yes. Let's be consistent. I would just suggest to you our system of government cannot survive if it's going to be politics all the way down. Thank you, Mr. Chairman.
Can I briefly respond?
Sure.
I mean, you invoked democracy a couple of times there, Senator. Judges are part of our system of democracy. Democracy is not as simple as majority rule. Judges have always served something of a
You would have it be as simple as
function.
majority rule. When you get the majority you like, you're for the nationwide injunction. When you don't, you're not.
Let me break it down for you. The entire hearing was supposed to be about the remedies courts are using, not about whether Trump was right or wrong in various rulings, but about how judges are now binding people and parties who weren't even in the courtroom. Let that sink in. They're issuing nationwide rulings that can tie the president's hands, grind government action to a halt, and override democracy, all from a single federal judge's bench. And guess what? When Trump was in office, these liberal scholars and left-wing legal commentators were all for it. Nationwide injunctions were their favorite weapon. It was like Christmas morning every time a Trump executive order got blocked coast to coast. You heard Professor Shah herself back. Then she called those rulings a travesty to democracy. But the moment the tide turned, the moment Joe Biden got behind the resolute desk, suddenly these injunctions were a threat to the rule of law, undemocratic and dangerous. Now they're clutching their pearls, terrified that a conservative judge might dare use the same tool. So let me get this straight. When liberal judges stopped Trump, it was a heroic defense of justice. When conservative judges stop Biden, it's the end of the republic. Folks, that ain't legal analysis, that's partisan hypocrisy. And as a proud American who still believes in checks and balances, in separation of powers, and in equal justice under the law, I've had enough of this lawfare. I've had enough of cherry-picking judicial tools just to get the right outcome. The senator, God bless him, asked the right question over and over again. What's the principle? Where's the line? What makes a nationwide injunction okay under Trump, but not under Biden? And guess what? She couldn't answer. She danced around the issue. She tried to cite Marbury versus Madison Sure, a historic ruling. But even that doesn't give judges a license to impose coast-to-coast laws on Americans who weren't part of the case. That's not justice. That's judicial tyranny. Let's be real. The left's obsession with nationwide injunctions is about one thing: raw power. They know they can't always win elections. They know their policies are unpopular. So they turn to unelected judges in friendly districts to do what they can't do in Congress. One liberal judge in San Francisco shouldn't be able to overrule the will of millions of voters across 50 states. That's not how this republic works. That's not how the founders intended our legal system to function. You know, for over 150 years, our courts didn't use these kinds of sweeping injunctions. The republic functioned just fine. Presidents governed. Congress passed laws. Courts resolved disputes between actual parties. It wasn't until the 1960s, and especially under Trump, that this tool exploded in use. Wonder why that is? Because the left started losing in the court of public opinion. So they ran to the courts to force their agenda on the rest of us. So what's the takeaway? We need a return to constitutional restraint. No more activist rulings. No more single judges deciding national policy. And no more pretending that judicial overreach is okay just because you like the outcome. It's time for conservatives to stand firm for liberty, for law, and for equal justice. Let's hold these professors, judges, and politicians to the same standards, no matter who's in the White House. Because the Constitution doesn't change based on who's president. And neither should the law. If you believe in restoring sanity to the courts and standing up against activist rulings, smash that like button, subscribe, and share this video with your friends. Drop a comment below. Do you think nationwide injunctions should be abolished? Until next time, stay strong, stay informed, and never stop fighting for the America we love. God bless you, and God bless the United States of America.